In week 4, we looked at how the structure of shareholders and the fact that shareholders are now predominantly institutional investors affects governance. This week we're looking at other stakeholders. We're going to look at corporate social responsibility and employees. Key questions there are: should corporate law involve these other stakeholders? Is there a special case for employees? And also, how does the law currently involve stakeholders? Now, currently, as you know, shareholders have governance rights. They appoint and remove directors. They have influence to a varying degree in different jurisdictions. But of course, you could have a system, which is what this slide is about, where there is a shareholder meeting, but there is also a meeting of employees, of creditors, and of community representatives. And those constituencies each have governance rights in relation to how the company is run. So that would be a stakeholder governing model. So that would be one option. Another option is a representation of, not at the level of the shareholders, but at the board level. So you could have employee directors, you could have creditor directors, and you could have community directors. And a third way is to say employees become also shareholders, or employees or creditors are given shares or involve themselves as shareholders. And then golden shares is a term for a government involvement as shareholders. And here are some more options for involving stakeholders: giving them consultation rights, giving them information rights, but not allowing them to participate in the governance. And then a softer option is narrative reporting, where the company has to produce reports on its impact for stakeholders. And if those reports are unhelpful or meaningless, then there's no sanction other than it doesn't look good on the company. But writing those reports can create a process of self-reflection. The overall question is corporate law even the right channel? So this is a session about the question: does it make sense to involve stakeholders in the governance of companies? And if so, how? So there's various theoretical approaches to this. Agency theory says stakeholder influence increases, obviously, the agency costs of shareholders, but there are areas where these overlap. And then the disclosure facilitates the market. So the primary prescription of agency theory is always disclosure to inform the market. Now, the disclosure gives information to shareholders, but also to employees, customers, and civil society, and enables them to respond to the company. If you adopt the concession theory approach, you say, well, this is a quid pro quo. There's limited liability made available by the government through the Companies Act, and it's a matter for policy choice. Real entity theory, the question is, well, why would you not involve other stakeholders? And then there's some literature in further, which I cited, I think, which I referred to in further reading, and that's a question of, does the level of useful involvement of stakeholders, in particular employees, depend on the industry? So do we need to distinguish between radically innovative industries and incrementally innovative industries? And the classic example would be very little employee involvement in the UK, strong emphasis on financial services, incrementally innovative industries. In Germany, lots more employee influence in Germany, and we find strong focus on engineering. So these are examples of is an example of the participation of workers. I won't go through it in detail. You can look at the slides. Maybe one thing I will say is that's a sort of a statutory regime which requires worker representatives on the supervisory board, and in the most extended case, also on the board of directors or the executive board. So this is the maximum level of employee involvement under the statutory regime. There are sort of lesser levels of involvement depending on the industry and the size of the company. The Corporate Governance Code 2018 for the first time suggests employee involvement and does this in a form, so you look at provision 5 and 6, and the company can choose if this happens either through a director appointed by the workforce, through an additional advisory panel, or through a designated non-executive director. The difference between the first and the third option is that a designated non-executive director is appointed by the shareholders, but then it assumes the role of representing employee interests. And then there are also recommendations for whistleblowing effectively. So companies are encouraged to create a means for raising concerns confidentially and anonymously, and arrangement for proportionate and independent investigation. So what is good about employee representation? Employees are in a special position because they make investments, but are not as able as shareholders to diversify. Also, their involvement can improve decision making. Plus, employees who feel that they can take part in the decision making develop feelings of ownership, and that improves their productivity. Now, of course, there's a cost involved. The coordination cost is the word on the slide. So you need to run through a process of talking to the employees, taking in their views, going back to them, having a discussion with them. That costs time. And then, of course, there is a sort of employee representation, a certain cost involved. Okay, so, but it produces a security of tenure and wages, and that is, you can call a plus from the perspective of employees. Cons, there is an argument that employees tend to side with managers or directors, and so that is bad for shareholders. Employees don't bear entrepreneurial risk, so don't take decisions from that perspective. Employment contracts are incomplete, and they lack governance expertise. The next point is an empirical one, which says, strangely, the market doesn't supply it. Or not strangely, just we observe market doesn't supply it. Very rarely adopted voluntarily. And then the empirical evidence is employee representation, good or bad, is not conclusive either way. So perhaps we don't need it, because if it's not good for much, why have it? And here's an argument why employee representation would be a bad thing from the perspective of employees, and that is it compromises their position because they become socialized with the directors and so stop being able to pursue their own interests. Here's an example of consultation rights. So that is a form of talking to and consulting with employees outside of governance. And then there's another example of involving employees, that's worker ownership. How is that different from worker participation? Well, it's different in that workers also become shareholders, and they then bear a risk as shareholders. When does that work? Well, keep in mind that workers who are also shareholders need to also bear that entrepreneurial risk. So I think I told you in the seminar that when Enron went bust, there were many employees that lost their job, but also lost a significant part of their investment, because that was investment in Enron. So there's a diversification point. And employees are also shareholders already in the form of pensioners. And there's a question, that's a very big question we won't really talk about very much, but the question is, would it be right for the pension fund to influence decision making, or is it the role of the pension? So it's, to what extent is that the right thing to do? So for other stakeholders, questions are, how do you involve them? Through golden shares, through consultation rights, through information rights, through reporting. Those are creditors, the community, the general public. Should there be some involvement for them? A strategy that the UK has adopted is a strategy of narrative reporting. And that's sort of a corporate law strategy. And Section 172 of the Companies Act says that directors sort of manage the company in the interest or for the benefit of the shareholders as a whole, but having regard to the stakeholders. And then narrative reporting is a way of documenting that involvement. There's also narrative reporting on pay gaps, there's narrative reporting on energy and carbon, and there's narrative reporting on practices and performance. It's called narrative reporting to distinguish it from the financial reports, which contain mostly numbers. And so that's sort of an explanation of the engagement of the company in relation to these topics. I will not go through this in detail. I will also skip this. This as well. So that these are just, this is all you can read. This is all stuff you can read. So overall, the characteristics. Well, the idea is there's a sort of business case assumption of internalizing these externalities by asking companies, the directors specifically, to write a report. They have to consider these factors that may encourage them to integrate them better into their decision making, but also means that they become sort of subject to scrutiny from people who read the report, compare it with reality, and then are able to criticize this. So there's a sort of, the idea is, however, that if there's a conflict between shareholders and stakeholders, or between a short-term and a long-term strategy, these are to be resolved in the interest of the shareholders as a whole. And the strategic report, if it's incorrect, there is liability, but only if the director knew that the statement was untrue or misleading or was reckless in regard to this. And the Financial Reporting Council has published mandatory guidance on the strategic report. The Stewardship Code. The Stewardship Code doesn't speak to companies. It applies to institutional investors, in particular trustees of pension schemes and asset managers. And that stewardship code encourages, and you can see here what it encourages. It encourages responsible investment, management and oversight of capital to create long-term value. And what we are interested in the context of this is leading to sustainable benefits for the economy, the environment, and society. So the method is getting the institutional investors to report, to adopt certain principles and report in relation to those. And these are principles designed to lead to sustainable benefits for the economy, the environment, and society. It's not mandatory. Institutions can choose to adopt it and then to explain, but they don't have to. Principles are set out for asset managers and asset owners, and there are also principles for other service providers. And on this slide, you can see how these non-beneficiary, financially oriented factors are integrated. And also principle 8 and 9 sort of say a bit more about the stewardship code. So looking at the overall kind of revision perspective on this, what is this about? So first question is, should corporate law integrate the interests of stakeholders? And there you need to form a view. Are you in favor of that or not? And then if so, how should it be done? And the options are integrate stakeholder interests into the governance, or broaden the duties of directors, ask for disclosure with a view to facilitating shareholder pressure, ask for disclosure with a view to facilitating stakeholder pressure. You could also publish rankings, so a system where companies are ranked in accordance, as it is the case in the UK, with diversity, or you can establish an early warning system where companies report on particularly late payment practices. So that's a problem that usually concerns small and medium-sized enterprises that sort of supply, for example, a large supermarket, and supermarkets take a very long time to pay. And there you can establish an early warning system where as soon as that happens to one business, they can flag this and alert everyone else. So the overall question for this topic is, how should we integrate stakeholder interests? Or should we, in fact, actually, should we do this at all? So these are the questions that we are asking in the context of this topic.